mercies we ask in your name. Amen.
Amen. Thank you, Member Jackson. I have apology for lateness for Member Chuck. If anyone else has any apology, please indicate for the record. I believe Member Scott Motley will also be late, though she didn't formally ask to tender an apology. I know she's dealing with a matter in court.
And as I had indicated earlier, Chairman, I apologize for not for my late start, but for my early departure.
Grudgingly noted, Member Bunting. All right.
I might also give notice of my early departure.
So what happened? Pre-charge bail clause gone and you're all deserting the bill?
Not at all, not at all, not at all, not at all.
All right.
But as you know, Madam Speaker, Madam Chair, being Thursday
yes,
is not the best day for many of us in our constituency. Fix obligations.
Yes, I know these are challenging times, and sometimes members of the public do not understand the balancing act that is being done by us, given the different roles that we all have and what flows from those roles. As Member of Parliament, we attend to the work of the Parliament, but we also have to attend to the work of the constituents who enable us to be here, and through our presence and interaction with them, we get a better insight into the kind of decisions that we ought to take. All right. We have no minutes this morning, understandably so, because we were here yesterday and then the Parliament sat afterwards. The clerk preparing the minutes would have been here in the House. So I entirely understand. The remarks that I would have made, I will defer them until the minutes are ready, and go straight into new business to resume the clause-by-clause reading of the bill. We ended at clause 7 yesterday to begin at 8 today. So unless there is any housekeeping matter that is required to be stated at this time, I would ask that we continue where we left off yesterday, and I would turn over to the Chief Parliamentary Counsel, Ms. Judith Grant.
Good morning. 8, conditions of bail. 1, where a defendant who is charged with or convicted of an offence is granted bail, any one or more of the conditions specified in subsections 3 and 4 may be imposed if it appears to the deciding official that it is necessary to do so. A, for the purpose of preventing the occurrence of any event referred to in section 7.1a, or B, to enable inquiries or a report to be made into the defendant's physical or mental condition. 2, subsection 1 shall also apply to any decision whether to vary the conditions of bail. 3, the deciding official may require a defendant to whom bail is granted to provide at the defendant's option and as a condition for bail before the defendant's release, A, a surety to secure the defendant's surrender to custody, or B, a payment of a bond in such amount as may be specified. 4, the deciding official may require a defendant to whom bail is granted to do all or any one or more of the following. A, inform the deciding official if the defendant intends to leave Jamaica. B, report at specified times and dates to a police station. C, comply with such other conditions as appear to the deciding official to be necessary. 5, the conditions referred to in subsection 4C may, where the deciding official is a court, include A, the surrender of the defendant's travel documents to the court having jurisdiction in respect of the offense. B, the imposition of a curfew in respect of a defendant to whom bail is granted between the hours specified by the deciding official, requiring the defendant to remain within a specified locality during the hours so specified. C, the wearing by the defendant of an electronic tracking device to allow for the monitoring of the movements of the defendant, being a device in accordance with such specifications and characteristics as shall be prescribed.
Member Campbell Rodriguez.
Thank you so much. When under 8.4a, it says, inform the deciding official if the defendant intends to leave Jamaica. Is it any deciding official? That's one. So it could be a JP, or does it have to be a police officer? That's a question. And then the second question is, does the deciding official have the right to say you can't leave the island?
You want to take a shot at the answer, Madam CPC?
Sorry, I didn't hear the very last part.
Does the deciding official have the right to say you can't leave the island?
Oh, okay. Well, all right. So the previous sections, clauses of the bill had set out who can grant bail in what circumstances, or who can consider the issue of bail in what circumstances. In some instances, for example, specified offences, it's only a judge. So in those cases, the deciding official would be a judge. In other cases, for example, the pre-charge bail, it would have been the constable or the justice of the peace. So deciding official there is used to apply to any one of those in the circumstances, right? So the deciding official here, of course, is that person who would have been deciding the question of bail. In terms of whether they can decide that the person not leave Jamaica, 4A requires informing the deciding official if the defendant intends to leave Jamaica. So implicit in that is that the person is allowed to leave Jamaica. It's just a requirement to let the official be aware.
Why it was not, outside of just informing, why is there not something where a decision can be made as to whether or not the person is allowed to leave the Jamaica? So let us say you're out on bail for something which, I don't want to use the word egregious, but is there a reason we don't have a clause which says that someone should be able to decide whether or not this person, rather than just informing? Or did I miss that clause?
There is.
Okay.
All right. So these kinds of conditions are designed and targeted at monitoring whether a defendant is a flight risk and therefore would not return to stand trial. And so for persons who are engaged in criminal proceedings with a view to answering a charge, depending on the risks assessment made, they may be prohibited from leaving the island, because after they are out of the jurisdiction, there is difficulty in getting them back to surrender to custody. And so we have balanced how and to what extent we engage the right to freedom of movement. And that is why the surrendering of the travel document, which really amounts to a stop order for overseas travel, is one condition that we have reserved to the court. Not all defendants will pose the same flight risk. And you do have persons who are answering to charges, persons who are under investigation, where on assessment, having regard to the other business that they are carrying on, they may require travel overseas. So depending on what the assessment is done into the antecedent of the defendant, we have permitted a two-stage. So you notify. In other words, if, for example, another condition is imposed requiring you to report to the police station and you're going to be overseas during that time, you would be in breach of that condition. So by reporting, indicating that you would be out of the island, then note can be taken of the reason for anything. Mr. Foreman, you want to add anything to that?
No, Minister.
Yes.
You had mentioned that a condition could be surrendering of travel documents.
Right.
So if the court decides that travel would be a problem, that condition would fix it.
It's just for me to understand, Minister. If the court did not take the travel documents, is it then that anyone whose documents weren't originally taken would then be eligible for permission to travel?
It depends on what the condition is, you know. The condition may specifically require that if you are leaving the island, you must inform the deciding official, if it were the police, the justice, or the court.
Okay.
So the condition may or may not be imposed. It depends on the merits of the case and the antecedents of the defendant in question. But at the end of the day, so if you note that the conditions relate to what is necessary and also to obtain certain objectives. Mm-hmm. The reference to 7.1a, and again, that is part of the design of it. So matters are not at large. And it's with a view to ensuring or to avoiding a failure to surrender to custody, avoiding commission of offense, and avoiding interference with witnesses or otherwise obstructing the course of justice, whether in relation to the defendant or to any other person. So it tells you that where the defendant who is charged with or convicted of an offense is granted bail, any one or more of the conditions specified further down may be imposed if it appears necessary to do so for the purpose of preventing the occurrence of a failure to surrender to custody, preventing the occurrence of the commission of an offense, and preventing the occurrence of interference with witnesses or otherwise obstructing the course of justice. So conditions are not being imposed at large. They are being imposed in a targeted way, having regard to the duty that is imposed on a defendant to surrender to custody and the fact that failing to surrender to custody amounts to an offense. And that goes back to the conditional or unconditional release. And that is why there is a discretion to impose the conditions or not, depending on what is being assessed around the particular defendant and in the particular case.
You, Madam Chair. And there is always the provision which provides for variation, like a variation of the bail. Because, just to be practical, we have had circumstances in the court where clients have been ordered to surrender travel documents. But during the life of the matter, in most instances before it comes to trial, we have had instances where we have applied for a variation for the particular accused to travel in certain circumstances. And the courts have varied conditions and allow travel in those circumstances.
That is why a feature of the law, striking the balance, is to provide an avenue for an application on both sides of the equation for variation and for an assessment to be done on the merits of the application. And you are right, Member Williams, that there are cases, many in the jurisdiction, where a condition of bail is a surrender of travel documents, and the defendant, having a need to travel, apply to the court for the release of the travel documents. Mm-hmm. Some have returned, and we have had cases where they have flown and not returned. So an assessment has to be done on the merits of the case. Yes, we have many people who are at large right now, for whom warrants of arrest have been issued, waiting to be executed, and some of them for many years. I mean, there are so many examples. Member Charles?
Good morning. With the issue of a surety to secure the defendant's surrender to custody, a surety, where in the bill can we possibly introduce or include bail bonds or anything like that?
The other limb of it is really what the bond is, the payment of the bond in such sum. So this feature is in the current law, and it really allows an option. there may be persons who prefer to be their own surety and post a bond, and there is also security that is granted. These are standard provisions in the law on bail and currently exist in our jurisdiction and in other places. Right? But what you're seeing in the rewrite is a lot more, is a greater care in the design of how and specificity around what can be done and should be done to minimize risks of injustice and abuse. Right.
Because
so at the end of the day, each matter is really being assessed on its own merits against clear principles of law.
So we currently have bail bond shops here. Because I saw a submission with that, and I didn't know.
Right.
So that's already included.
We have made some new provisions. When we come to the provisions dealing with surety, we will indicate how we have tied it up and what we have added and why we have added. All right? Any other question or comment? We can move to clause 9.
9. General provisions relating to bail. 1. A defendant who is granted bail shall surrender to custody. 2. Where a deciding official has granted bail, the deciding official may, on application by A, the defendant to whom such bail is granted, or B, the prosecution or a constable, vary the conditions of such bail or deny the application.
This is exactly what Member Williams just raised. So an application can be made by either side, the defense or the prosecution, to the deciding official that granted the bail to vary it. So if the bail was granted out of court, what it means that it can be varied out of court. If it were granted in court, it can be varied in court. And that again, too, is to allow for greater efficiency in decision making.
I hate to revert to clause 8, it's 85C, in relation to the tracking device. Yes. I recall there was a submission that...
Oh, by the way, thank you for highlighting that. This is new. Yes. I mean, it has been called for, and although there was general agreement in the court that it could have been done without legislation, this is one where we have put in. And I know Member Charles in particular, when she spoke in the House and referenced some examples of heinous crimes in her community. I think there was one that dominated the headlines of the news. She spoke to her own view of the positive difference a tracking device could have made in the circumstances of the cases she spoke about. I think generally from our monitor of public commentary, this is one that is welcome and one that has been called for. And of course, the specifications will have to be determined, and that is why they will be prescribed. We had a comment from the JCF to create an offense if someone is fitted with a tracking device, if they tamper with it or they destroy it. And I think, yes.
So why I raise it is just to ascertain whether the submission of the JCF is being considered seriously.
For the avoidance of doubt, all submissions will be considered, some more seriously than others, some at greater length than others, but all will be considered. Yes. I think we're having a little challenge with the mic, which will affect the record. So the CPC is just changing seat.
Thanks. 3, where a defendant is denied bail in relation to the offense concerned, the defendant may make a new application for bail at any subsequent hearing in the proceedings for the offense on the grounds that A, there has been a change in circumstances affecting the matter since the previous application for bail, or B, there are facts applicable to the matter which were not available to the deciding official at the time when the decision was made. And those circumstances or facts, as the case may be, are relevant to the question of the grant of bail to the defendant.
This is a real tidying up of the provision, again having regard to our assessment of how judicial time is used and to provide greater clarity to defendants to ensure that, when a subsequent application for bail is made, it can be properly considered. Real improvement on what exists now for guidance.
4, bail granted.
Madam Chair, if
yes,
I
Member
may,
Jackson.
in that clause, I note clearly the conditions for making an appeal after it was denied. Suppose, Chairman, I go before a judge and I feel that the judge was particularly hostile to me who is seeking the bail. And put it bluntly, suppose I feel this judge is really a pro-police judge, believes everything that the police has gospel and is biased. Can't I, on that basis, seek to have my bail hearing before another judge?
So decisions can both be reviewed if it's for variation, or they can be appealed and the grounds of appeal set out. So a denial or a grant of bail can be appealed. Yes.
That would be a separate appeal process.
I'm sorry?
No, I was reading it on the clause 9, right? Where it says, where a defendant is denied bail in relation to the offense concerned, defendant made that. And it went on to give the condition that.
Yes, so a fresh application may or may not be before the same judge.
Why such a provision can't be like on the 9.3, similarly where you have A and B?
9.3?
9.3 sets out, A and B clearly sets out the grounds for which you can be making this appeal. Correct?
A fresh application. So currently, the law says that an application may be made subsequently. Mr. Foreman, do you have it to hand?
Just point out, Clause 12 deals with.
And I think Clause 12 may address what you are asking for, Member Jackson. Appeals from decision of a judge.
Okay.
Yes.
I differ.
But what you will see with these provisions is significant improvement and clarity on what currently exists in the law, and also reflecting the best practice. Please proceed.
4, bail granted to a defendant who has been charged with or convicted of an offense shall be revoked by a court if A, the defendant fails to surrender to custody, B, the court is satisfied that the defendant has absconded, C, the court is satisfied that the defendant has breached a condition of the bail, D, the court is satisfied that there are reasonable grounds for believing that the defendant committed an offense while on bail, or E, the revocation is otherwise justifiable under any provision of Section 7, unless the court is satisfied that the defendant has provided a reasonable excuse why bail should not be revoked under this subsection.
So while clearly setting out the circumstances in which bail may be revoked, it also provides an avenue for an explanation to be given and assessed by the deciding official. Yeah. Member Charles?
So the removal of an electronic tracking device would probably fall under the breach of conditions of bail?
Yes, Yes.
Okay.
Any condition imposed, if any of the conditions, many conditions imposed is breached. Yes.
10, recording and giving information on decision concerning bail. 1, subject to subsection 2, where a deciding official A, grants bail or refuses bail, B, appoints a time or place for a defendant who is granted bail to surrender to custody, C, imposes or varies any condition in respect of bail, or D, revokes bail, that deciding official shall, in the prescribed form, make a record of the decision and shall cause a copy of the record of the decision to be given to 1, the defendant, and 2, the prosecution, or, in the case of a defendant who has not yet been charged, to the police, as soon as practicable after the record is made.
Just to say that we note the recommendation for a form to be, for the prescribed form to be included in the schedule as opposed to made by way of regulation. We'll see. But the comment, the suggestion and the comment made by the presenter clearly is already reflected in the approach that we're taking. Yes.
2, where bail is granted to a defendant by endorsing a warrant of arrest, the constable who released the defendant on bail shall make the record required by subsection 1 instead of the judge or justice of the peace, as the case may be, who issued the warrant. 3, where a deciding official A, refuses bail, B, imposes conditions in granting bail, C, varies any conditions of bail, or D, revokes bail, the reasons for the decision shall be given in accordance with subsection 4. 4, a deciding official who is required under subsection 3 to give reasons for a decision shall note those reasons in the prescribed record and shall cause a copy of that note to be served on the prosecution and on the defendant concerned or on the defendant's representative within 48 hours after the decision is made. 5, where a decision referred to in subsection 3 is made in respect of a defendant who is not represented by an attorney at law, the deciding official shall inform the defendant of the procedure for review under section 11 or the right of appeal conferred by section 12, as the case may be.
Just to say that these provisions really seek to clarify and address systemic injustice issues where decisions are taken and people are waiting for records of the decision, because these matters have far-reaching implication, and just to ensure also timeliness in dealing with in dealing with providing the reasons. And because of the overall scheme of the law, it's very clear the grounds on which a denial may be done, on which a grant may be done, on which conditions may be imposed, on which variations may be done. And just to minimize the delay between the decision-making and the preparation of the record, we have prescribed the forms so that they can be filled in and also filled in fully and comprehensively. And the matters are, and the reasons are given in writing to affected persons.
A question. What happens if this is not done?
We haven't provided for, it really would amount to a disciplinary action, you know. So, Madam CPC, did we consider how we were to treat it, or we decided that this was not the bill in which to deal with those matters?
Because I just want to say, I like the idea of it, and I think it's important.
Yes.
I would just like to know, consequences if not done.
This is something that the defendant could take up as a matter on review. It would be the failure to give reasons in administrative law is a substantive ground on which an appeal can be taken, because the deciding official would not have been acted according to the principles of natural justice. So it could form a ground of appeal for the defendant.
If someone, and I'm just putting a theoretical case here, maybe making the suggestion that is there any way for that to be included in the bill or somewhere, because what if it's a matter of a client who is not being represented by an attorney at law and therefore wouldn't know that this is something for grounds of appeal?
Round of appeal currently. I don't know. Mr. Foreman, you don't want to give a view on it. So it really comes back to standards of behavior and conduct when persons are entrusted with functions. Not everything can be provided for in the Bail Act itself, but it is an issue that we discussed behind the scene, and part of the public education and part of the government education that will have to take place after this bill becomes law include constant reminder of what needs to be done. But the CPC said in administrative law, where statutes impose duties and confer benefits, how those statutory duties are exercised can be reviewed. All right? So there are standards.
Chairman.
Yes, Mr. Jackson?
That point is one that detained me also. And I hear you, Madam Chairman, about the review process. I hear about the provision in other legislation. But I come to this point from a different angle. Ordinary citizen John Brown, who is picked up and is denied bail, he doesn't know what you or I know, and many people are educated, don't know these provisions. And because somebody failed to tell the person what his rights are, he suffers the indignity of incarceration and all of that, while it's just a breach for the officer. Just a breach. And might be reprimanded or might even be suspended. But the person who is not able to take the recourse that is provided for in law suffers in the interim. From where I am, Madam Chair, if the person who fails to do that, it would make for automatic release of the person.
But Jackson, I think...
No, let me tell you why I'm pushing to that extent. And it might seem excessive on the face of it. It might seem excessive. When we know that there is a real serious consequence to our failure, we have a different attitude. And I am particularly concerned about those persons who don't have access to resources that you and I may have. You and I get caught in a situation where we are going to be arrested and bail is going to be denied. We can get a call or a message to an attorney, right, without even have to discuss fee before to see to our release. We have those luxuries, but many people out there don't have it. And they are going to be put down or put in that circumstance because somebody failed to do what the law required them to do. And that's why I believe Senator Rodriguez's question is significantly a valid one, and it's one that should not be brushed aside and left to be dealt with in due process.
I share the concern. Oh, I'm sorry, let me start again. I share very strongly any concern raised about conduct of public officials in the discharge of their duties. I think we have too many examples of falling short. And the consequences that flow are severe or they vary. Some are severe, some may be slight. But we have to, at the same time, take care that we do not conflate issues. When we come to do the constitutional reform on the public sector, and in particular the rewrite of the public service regulations, these are matters that will have to be looked at in a new way, given what the Charter of Fundamental Rights and Freedom require of persons in government. So I can tell you that the work has already commenced and is at a different stage. But I can see immediately how a failure of an errant police officer, for example, to provide the written document could amount to monumental injustice if we were to legislate that the defendant in such a case be released. So take, for example, you, Member Jackson, find yourself in the unfortunate situation of witnessing a horrible crime. And even more unfortunate, it is somebody that you know very well. And the person is apprehended and taken to the police station, and the issue of bail is considered, and the officer fails to provide the document and then release the person. And the person say, you know what, I'm gone. So we shouldn't conflate the issue, because the reason for the defendant's detention has to be assessed differently from any failure or omission by the public official who's required to keep and produce the record. As two different tracks we're dealing with, and we might fall into error if we were to conflate them and accede to the
Madam Chair,
request.
with due respect, it's not a matter of conflation. I remember very clearly the gentleman who was, quote-unquote, lost in the system and spent over 40-odd years in prison. And all of us got up in Parliament and mourned the fact that this gentleman was subjected to what he was subjected to. That is his reality. And that's not an isolated case where the system failed and people suffer as a result of the failure. So there's no conflating of the issues here. This is real life for many people out there. And worse yet, on the streets every day, that they are to be arrested or required and to be bailed. That's reality for people. But you know what the problem, Madam Speaker? Too many of us are too removed.
I'm not the speaker.
Madam Chair, you're the speaker for today. Right? Too many of us are too far removed from those realities of everyday Jamaicans. And sadly, it is only when it's somebody who is known to us personally that we claim it to be a crisis, something to be fixed, something to be dealt with. But this is everyday reality for many people. So if we can fix it now, which is what Senator Rodriguez is speaking to and would like, much the same as I do, would like us to put it in the law. Because another thing I've come to learn from lawyers, Madam Speaker, even when you go to court, a judge only looks at what is before him or her and don't bother to look on other legislation. And the truth of the matter, some lawyers not even, well, quite frankly, are not aware of some of these provisions to bring the judge back to these provisions in considering the case that is before them at that point in time. And what happens? An accused suffers. And you see, when it comes to people's freedom, Madam Speaker, Madam Chairman, is something that I attend to delicately. I don't want any person guilty of any crime to be running up and down on the street and possibly committing other crimes. But at the same time, I'm very concerned about an innocent person being subject to the indignity of incarceration unduly. And when things can be done to minimize, not necessarily even prevent it, but to significantly minimize it, it is incumbent on us to do all that we can. And if it means to be repetitive in this law, so be it. So be it.
All right, Member Jackson.
Time to time I hear it is in another law.
Member Jackson.
Does not take place in the courts.
Member Jackson, I share the view. I share the view that consequences should flow where there is an omission, especially where the statute creates a duty and the duty is breached. And generally, in law, there is a remedy for that. Generally. All right? I know because we are dealing with so many issues, we sometimes get very excited and think that all of the problems should be resolved in one action and one piece of legislation. But the dispute, there would be various disputes and different disputes in the scenario you pose. So the immediate victim of the crime, there would be a dispute between that person and the defendant. And then there would be a parallel dispute between the defendant and the deciding official who has failed to keep the record. The two disputes have to be looked at in their own context and on their own merits. And we may risk creating a greater harm if we were to accede to the request in the form that you are making, to my mind. This is not to say that we shouldn't consider, because when we were developing the law, I contemplated what, if anything, should be put in here when the mandates are not complied with. And I have been on record repeatedly of speaking to the need for a different set of rules for persons who work in government. The example you cited about the defendant who was lost in custody, I can tell you that one of the first cases of lost defendant in custody was dealt with by me in the Black River, then resident magistrate court, with the Jamaica Independent Council of Human Rights and Nancy Anderson of blessed memory dealing with. And I personally was instrumental in getting the release of that gentleman who had languished in custody. We've had recent cases, because in my former role as Attorney General, we have had to deal with them. And Mr. Foreman from the Attorney General's chambers is here. These are matters that we have had to deal with. And the omission in that case was an omission, a judicial omission, because there is a process by which the persons were to be tracked. So I don't want you to think that the concern is not shared or there is any minimizing. The sole issue is where do we provide for it more appropriately.
You're calling from?
That's the sole issue.
Okay, no, address it to me.
So
yes.
It is not that you care any more than we do, because it is a real concern. But one piece of legislation cannot, because legislation are subject matter appropriate, address all of the problems. But we will take note whether we provide for any failure amounting to disciplinary action to be dealt with by the appropriate authority.
With your
Mr.
permission.
Foreman, you may advise us on that.
With your permission, Madam
after
Chair.
proper consideration. Yes.
Madam Chair, just a query here. The reasons here to be given, are these reasons with a view to facilitate a review or an appeal? What's the purpose of the reasons?
Not a single reason, because these are people who would have been formally engaged with the criminal justice system and are at various stages of criminal proceedings, whether investigatory or awaiting trial or pending appeal. The persons who are on bail may have to account to their employers. The record may be required, but they also will enable review and appeal where necessary. But it is just to ensure that persons who are formally brought in to the formal criminal justice system and are put on bail or are denied bail have the records. They are not only kept within the system, but that they are given to them. And this is part of, again, how the evidence and the data features in the law. It's a point of concern that has been raised, not only in relation to questions of bail, but to other matters. As a matter of fact, Counsel, you would know that one of the biggest injustices, cries of injustice right now, is the long time litigants are waiting for records. Records of appeal, records of trial, etc. Long time. So that when we say to you that many features of the law reflect the evidence we have reviewed, this is also one part of it, because there is systemic injustice too, separate and apart from the people-to-people actions and omission, how the system deals with the person who is brought in can be deep, deep, deep points of concern.
Why I ask,
Yes.
Madam, and I don't know if I'm assessing it correctly or I'm down the right street, but in my view, if it is that the reasons, let's say the deciding official fails to provide the reasons as required by the statute, in my view, it doesn't prevent review.
No, not at all.
It doesn't
not
prevent
at all.
a review, and it doesn't prevent
as it doesn't know either. Right.
Because I've had cases
but
where
it
that has
can
happened.
delay. It can delay matters.
But
yes. Yes.
and perhaps I see where you're going in terms of, because if we make it, if we were to be strict and draconian to say if you don't provide the reasons within 48 hours, then a person goes on bail, that in itself could create a problem.
But is a wrong,
would have a floodgate.
But not only that, it would be a wrong assessment.
Yes.
Because the denial of bail is not, grant or denial of bail is not dependent on whether a record has been produced.
Yes.
But it has to do with the nature and the nature of the offense, the gravity of it, the antecedents, all the matters that are set out in law. So we have to make sure that in trying to resolve one problem, we don't create other problems.
I'm thinking internally and administratively, Judge, if this would be a perfect scenario for a practice review. Sorry,
we make reference to the rules, though, we make reference to the rules. We make reference to the rules,
yeah.
right? So
because
it's not the Parliament that would issue the practice direction, but the courts.
I know we couldn't do
Yes.
that. But I'm just saying, probably, that's what I'm saying, administratively, that could be taken care of. Very well.
But Member Jackson, just to say that, a lot of the things that you read about, I have seen them firsthand, dealing with both sides of the justice equation, defense and the prosecution.
I don't only read about them, Madam Chair. I encounter them out there on the ground.
I guess all of us as members of Parliament
hypothetical.
do. All of us as members of Parliament do. The point I was making, though, is that when you encounter them in court, you're encountering them in a formal way where rules apply, because the formal justice system is a rules-based system. Right? We can proceed?
Yeah, but I hear you, Madam Chair. It is a rules-based system, and those rules relate to people's realities. Let us not ever forget that. The rules relate to people's living reality.
But you and I are not on different pages, Member Jackson.
Esoteric.
We are agreed that consequences should flow where a duty is imposed and there is a breach of the duty. We're on the same page. I may have just said it differently. I may have just said it differently from you, because the debate is not whether the errant official ought be held responsible. That's not it. It's where do we prescribe it? And even without it being prescribed, the law does provide redress.
Yeah, my difficulty, though, Madam Chair, is that when we would have recognized it, things stop right there.
Sorry, is?
Let me continue. That's where my discomfort
I didn't hear you, Member Jackson.
I'm saying that where my discomfort comes is that many of these things we recognize and we talk about them. But when the talk is over, for the moment, those realities prevail in people's lives daily. That's where my discomfort lies.
Member Jackson, maybe you have not
Continuous.
looked closely enough at my own antecedents and my efforts to provide solutions.
I'm
to
not
pressing
talking about
problems.
yours, madam.
No, in
please
this,
don't.
no, I do have
I'm
carriage of the
talking
bill.
about as a system,
Right.
not you or me individually.
But it is precisely because of the awareness of the systemic issues why we have the provisions for record keeping and service of the decision, reasons for the decision provided for
Yes,
with such
yeah.
clarity here. It is precisely
Systems are-
because we recognize those conditions, those issues.
Systems are only as good as what they deliver.
And there you lend support to the point I'm making that not every problem can be addressed at the same place.
Some of them take too darn long, Madam Chair. That is my
But
problem.
me and you agree on that too.
Suffer.
You and I are agreed on that too, Member Jackson.
I must admit, I'm a little bit impatient with the talk in the absence
But this
of
is not talk, Member Jackson. Members of the public have cried out to us, speaking about how long it takes for them to get records in the court. And in this bill, we are prescribing the forms, setting out in detail what is to be included in every decision taken. We are
Madam
providing
Chair,
the documents
I will
in the law. Hear me
terminate
out,
my
Member
submission
Jackson.
on this.
No, man, hear me out. In the law, these provisions are providing solutions. Let us not find problems
I
in the
hear you.
solutions.
I hear you. I hear you, Madam Chair. I hear you. Let's go on. Let's go on.
Very well.
Clause 11, review of bail decisions. 1. A decision by a constable or a justice of the peace on the matter of bail to a defendant shall be reviewed by a judge of the court having jurisdiction to try the offense concerned, A, on the defendant's first appearance in court in relation to the offense, B, in the case of a refusal to grant bail or a decision to impose any condition in granting bail, on an application by the defendant on any ground specified in subsection 2, C, in the case of a decision to grant bail or the failure to impose a particular condition in granting bail, on an application by the prosecution on any ground specified in subsection 2. 2, the grounds...
Pause there. So, Member Jackson, here is an example now. It can't get any fairer. And it addresses the issue that you had raised earlier about reviewing the decision. So anyone who is granted bail out of court, on your first occasion in court, the court is empowered to review it, to make sure that the decision was properly made and properly and the right balance struck. But not only that, you are empowered to apply to have the matter reviewed. And when I spoke earlier about striking an appropriate balance and ensuring that what we are providing for in this rewrite takes into account issues raised, not just on one side of the justice divide, but on both sides, and providing in as fair a manner as possible. This is an example of that provision too.
Okay, Madam Chair.
Proceed.
2, the grounds referred to in subsection 1 are, A, there has been a change...
And by the way, it applies to all defendants, be they suspect, accused, or convict. This is an example of when the CPC said some of the provisions in order to effectively cover persons at all three stages. This is one example. Madam CPC?
That doesn't negate the point, Madam Speaker.
I'm sorry?
With all due respect, that provision does not negate the point about the term defendant as against suspect.
Does not negate which point? For some reason I'm not hearing you well, Member Jackson.
I don't know, maybe because my video is on. I was only saying, I figure you were referring to the discussion about the use of the term defendant as against suspect and what the provisions are for bail here in section 11.
I don't bother call Member Rodriguez's name today because we're all agreed that the person suspected of committing the offense is a suspect. But so we're not on different pages on that.
No, you're not going to stop me from calling her name.
Don't call her name.
Call it eternally. Anyway, I think the point is made.
Yes, but Justice, in
Let's go.
fairness to the CPC, here is a classic example which grounded the point that she made. All right, proceed, please.
2. The grounds referred to in subsection 1 are: A. There has been a change in circumstances affecting the matter since the previous decision in respect of bail, or B. There are facts applicable to the matter which were not available to the deciding official at the time when the decision was made. 3. A judge of the court concerned shall, at least once every 2 weeks, carry out a review of cases involving defendants who were granted bail in relation to offences tried before that court, but who were unable to take up such bail. And for the purposes of this subsection, a list of those defendants shall be supplied to the court on Monday of each week in respect of the preceding week by A. In the case of defendants held in lockup, the police officer in charge of the lockup; B. In the case of defendants held in a correctional institution, the individual in charge of the institution.
Member Jackson, here comes the provision to ensure that insofar as the legislator's duty go, no one should be lost in custody again. Here is the provision, a reflection of the evidence and the data that we review. And also because me, myself, for emphasis, have done it when I was on the bench and understand the merit of it. So the very concern that you were raising, right? We're imposing a mandatory duty on the judge to ensure that everyone who is in lockup is reviewed fortnightly.
Most welcome, Madam Chair.
But I was telling you that the bill strikes
Madam Chair,
the
we
right
need not argue
balance.
about what we agree on. We need not argue about what we agree on.
No.
That's
but,
our duty.
No, man. I was saying to you, Member Jackson, that the concern was shared. And when we talk about the bill being evidence-based, these are the provisions that reflect the evidence we consider and the concerns that have been constantly raised in the criminal justice system and in the wider society on issues. And they are being addressed. All right?
Which is welcome.
Right. And you notice we cover everyone. We make sure we identify precisely who has the duty to make the list. Precisely. So nobody can escape responsibility at the end of the day. That is part of the careful design of the provision.
4. On a review under this section, the judge, A, may affirm the decision reviewed, grant or refuse bail to the defendant, impose conditions on bail granted to the defendant, or remove or vary any condition of bail imposed on the defendant. B, in the case of a review under subsection 1, may revoke bail granted to the defendant, or C, in any case where section 5.4 applies, shall make such order as the court considers appropriate.
You know, I mean, so far, we have only had negative reports on the bill. You know, the concerns from one extreme to the next. And this is not to say questions raised seeking explanations and clarity are not taken. But sometimes we conclude too early. Or sometimes we haven't read, or if we have read, we haven't digested what is being provided for.
Okay, madam.
Clear improvement.
All right, we'll go on.
Continue, Madam CPC.
5. In subsection 3, correctional institution has the meaning assigned to it in section 2 of the Corrections Act. 12. Appeal from decision of judge. 1. The defendant concerned may, in accordance with any applicable rules of court, appeal to A, a judge of the Supreme Court in chambers, in respect of a decision made by a judge of the parish court. 1. And referred to in section 5.7a or 10.3. Or 2, upon a review conducted under section 11. B, a judge of the Court of Appeal in chambers, in respect of a decision made by a judge of the Supreme Court. 1, and referred to in section 10.3, or 2, upon a review conducted under section 11. 2, where bail is granted to a defendant by a judge of the parish court or a judge of the Supreme Court pursuant to this act, the prosecution may, in the manner set out in subsection 3, appeal to a judge of the Court of Appeal in chambers in respect of the decision.
Just to say again, we have made it clear where the appeal lies from which decision. So there should be no confusion depending on where the decision is made, to whom you appeal.
3, where the prosecution intends to appeal a decision to grant bail to a defendant, the prosecution shall, A, at the conclusion of the proceedings in which the decision was communicated and before the defendant's release from custody, give to the judge of the parish court or judge of the Supreme Court, as the case may be, oral notice of that intention, and within 72 hours after the conclusion of the proceedings referred to in paragraph A, give the judge of the parish court or judge of the Supreme Court, as the case may be, and the defendant a written notice of the appeal in the form set out in the 3rd schedule, setting out the reasons therefore.
And just to say that this practice currently exists, what we have done is tidied it up and look at the prosecution have been crying out for a little more time to provide the record. You know, take for example, when we are here every day, a prosecutor who goes out on circuit and is in court every single day and is out, not near the office of the DPP. Administrative matters sometimes take time. And again, we have just tidied it up and ensure that justice can be done in each case.
4, subject to subsection 5, upon receipt of the oral notice referred to in subsection 3A, the judge shall remand the defendant in custody until the appeal is determined.
And that is what currently obtains.
5, where the prosecution fails to file a written notice of appeal in accordance with subsection 3B, the grant of bail shall take effect immediately on the expiration of the period of 72 hours allowed under subsection 3B for the filing of the notice of appeal.
Member Jackson, here is a good example of where there is omission on the part of the state to do what needs to be done, where you have a release of the person. Member Jackson?
Because the bail would have been granted previously.
Here is an example where we consider it most appropriate if there is failure on the part of the state official to do what is to be done, that the defendant is to be released.
6, the hearing of an appeal under this section shall be commenced within 120 hours, excluding Saturdays, Sundays, and public general holidays, or such longer period as the judge in chambers may, in any particular case, consider appropriate, after oral notice is given under subsection 3A. 7, on an appeal under this section, the judge in chambers may affirm the decision that is the subject of the appeal, or grant or refuse bail to the defendant, or vary or remove any condition of bail imposed on the defendant. 8, for the purposes of subsection 7, the judge in chambers may direct the defendant to appear at any time and place which could have been directed by the deciding official, and the recognizance of any surety provided in respect of the defendant shall be conditioned accordingly. 13, bail after conviction.
Say before, the subsection, subclause 8 is also directed at greater efficiency in taking recognizance in circumstances where bail has been granted. So if someone is out in a parish, they don't really have to, it doesn't have to be done in Kingston or in a manner that puts them at great inconvenience.
13.1, a defendant who, A, is convicted of an offense other than an offense listed in Part 2 of the 2nd Schedule, B, was out of custody on bail immediately prior to the conviction, and C, appeals against the conviction, may apply to the judge before whom the defendant was convicted or to a judge of the Court of Appeal for bail pending the determination of the appeal. 2, that should be on an application, not on an appeal. On an application under subsection 1, the judge may grant the application if satisfied that exceptional circumstances so warrant, and impose such conditions on the grant of bail as the judge considers appropriate.
So members may be reminded that we got very studied comments on the post-conviction or bail pending appeal provision from Mr. Jarrett, and I think we will duly consider those matters on this regime when we come to looking at it. And no doubt, Mr. Foreman, you will also provide us with comments from the chambers on that. Yes. Well, yes. Proceed.
14, absconding by a person released on bail. 1, a defendant who is released on bail commits an offense if that defendant, A, fails to surrender to custody, or B, having reasonable excuse for failing to surrender to custody, fails to surrender to custody as soon as possible after the time originally appointed for the defendant to surrender to custody. 2, in proceedings for an offense under subsection 1, A, it shall be a defense to a charge under subsection 1A that the defendant has reasonable excuse for failing to surrender to custody, and B, a document purporting to be a copy of any part of the prescribed record that relates to the time and place for the defendant to surrender to custody and duly certified to be a true copy of that part of the prescribed record, shall be evidence of the time and place appointed for the defendant to surrender to custody. 3, in subsection 2, duly certified means certified by A, where the deciding official is a judge of the parish court, the clerk or deputy clerk of the court. B, where the deciding official is a judge of the Supreme Court, the registrar or deputy registrar of the Supreme Court. C, where the deciding official is a constable, by that constable or the constable in charge of the police station from which the defendant was released on bail. D, where the deciding official is a justice of the peace, that justice. E, where the deciding official is a judge of the Court of Appeal, the registrar or deputy registrar of the Court of Appeal. 4.
Madam Chair.
Yes, Member Jackson.
Yes, at D, where the deciding official is a justice of the peace, that justice. You refer to justice of the peace as justice?
Yes, yes.
There's a definition in the Interpretation Act.
There is a definition in the Interpretation Act that deals with it, yes.
Is Member Chuck is on. The reason I raised it because
I am on Fitz.
Remember Chuck, the issue came up once in Parliament about justice of the peace being referred to as justice as against, which I personally thought that was reserved for judges of our courts, starting from parish court going up to the Supreme Court.
At the parish court level, the parish court is referred to as judge. His or her
Judge.
honor, yes.
Right. But the whole term justice, because I have had a difficulty with justice of the peace being referred to as justice in much the same way that our other judges are.
Cliff, Fitz, if I might say so, is something that has been discussed. One of the problems is that over the decades, these JPs have oftentimes been referred to as justice. I must admit, when I came as Minister of Justice, I think in 2011, somebody called me and said, "This is Justice so-and-so Brown," and I said, "But I don't remember that, Judge." And I was shocked. I was really shocked. But the truth of the matter is, I don't think it really matters on reflection, Fitz, that they actually call themselves, or our communities call them justice. You're going to get that sort of cultural challenges, and I don't think we can lay down a law.
No, I'm not. I was just clarification here.
No. You're right. You're right, Fitz. And one of the things, although many GPs serve as lay magistrates in the courts, I've often had discussions with them to indicate to the lay magistrates, you're not the equivalent of a judge.
I heard you saying that in the past. Call upon you in this instance.
So, right. Member Jackson, this is where you and I are on the same page, on the same line, within the same boundary. But Minister Chuck is right. The issues are deeper and longer than us. They are set in our justice system, cultural DNA for a long, long time. And I tell you, I have been confused like Minister Chuck. In my constituency, I remember we were having an event and someone welcoming Justice so-and-so, and I'm looking around to see which of the puny judges or the judges of appeal was present. But, you know, it's not going to be easy to change, but I would say to my colleague, Minister Chuck, that we probably could put our heads together and see whether the change should be made.
I have said, if I might say, I have said to the custodies and to the JPs that the term justice, refer to judges of the Supreme Court and the Court of Appeal. So it's more appropriate to refer to yourself as a JP or a justice of the peace, because sometimes people are like Minister Manalufort and myself. When people start referring to them as justice so-and-so, I'm really looking for a high court judge. But
same here.
Yes, but it's going to be a challenge.
It's one of those things that, and remember also that we do have a hierarchy of courts. I mean, the Court of Petty Session is not a court of record, and it's the lay magistrates who are the justices of the peace, specially trained to preside in the lay magistrates' court that are the presiding officers there. Outside of when the parish judge exercises the jurisdiction of two justices of the peace in the parish court, in the petty session jurisdiction of the parish court. But we really should give it a thought, Minister Chuck, and I know, it's not a new issue, notwithstanding how well embedded it is in the justice of the peace system, because in the hierarchy of courts, at the very bottom is the petty sessions court, and then you have the parish court, then you have the high court with its various divisions, the court of appeal, and at the top, the privy council. So, yeah, I take the point. We
can think about it.
Yes. No, but it's not a matter for this bill.
No. As I said,
I am just making the point again, teasing you, Member Jackson, because not every issue can be addressed in this, in any single bill. Yes. Please proceed, Madam CPC.
4. A person who commits an offence under subsection 1 shall be liable on A, summary conviction before a parish court to imprisonment for a term not exceeding 5 years, or B, conviction before a circuit court to imprisonment for a term not exceeding 7 years. And if a sentence of imprisonment is imposed on the defendant in respect of the offence in relation to which the defendant was released on bail, service of the sentence for the offence under subsection 1 shall commence consecutively after service of the first mentioned sentence.
Let me pause to just say to those who are listening, and firstly to members of the committee, that this issue of absconding bail is given a more severe treatment in this law. So you will see that we have increased the penalty on conviction. The matter is triable both at the parish court level and at the Supreme Court level. And that if you are found guilty at the end of the day, the sentence will run consecutively. That's after you serve the sentence for the matter that you were on bail if you're convicted for it. But in striking an appropriate balance and recognizing that things can happen, we provide a statutory defense. So we learned a lot out of COVID, we learned a lot. And we have endeavored to strike a balance, but let everyone know who's granted bail. Not only in respect of your failure to surrender to custody, your bail will be revoked, you commit an offense, and on conviction, you go into prison. This is not a fine. This is not a fine. If at any time you're granted bail and you are unable to surrender to custody at the time and place specified, make sure you turn up as soon thereafter. So you can have, if you have good reason. And that is why we also have been very specific, so nobody should be in any doubt as to the time and place that they are required to surrender to custody. We have also specified who should make the record and the extract of the record and how it is to be treated in law. When we looked at the data, we were told that the files piled this high, way above our heads, to bury many of us, however many feet tall we are, of defendants absconding bail. And a special request was made to make the offense triable also at the Supreme Court, because many of them who have matters in the Supreme Court, it would be more convenient to deal with them there. So be warned, tougher provision for absconding bail. And we have tightened it in every way to aid prosecution and make prosecution easy, but we have also provided you with a statutory defense.
15.
The penalty is one of imprisonment. 5 years or 7 years running consecutively if you are convicted for the offense that you were granted bail for.
15. Liability to arrest for absconding, breaching conditions of bail, etc. 1. A court may issue a warrant for the arrest of a defendant who, A, having been released on bail, fails to surrender to custody, or B, having surrendered to custody after being released on bail, absconds at any time before the conclusion of the proceedings for the offense concerned. 2. Notwithstanding subsection 1, a defendant who is released on bail may be arrested without warrant by a constable if A, the constable has reasonable grounds for 1, believing that the defendant is not likely to surrender to custody, 2, believing that the defendant is likely to breach any of the conditions of the defendant's bail, or 3, suspecting that the defendant has breached a condition of the defendant's bail or committed an offense while released on bail. Or B, in a case where the defendant was released on bail with a surety, the surety notifies the constable in writing that 1, the defendant is unlikely to surrender to custody, and 2, for that reason, the surety wishes to be relieved of the obligations as surety. 3, a constable who arrests a defendant pursuant to subsection 2 shall cause the defendant to be brought before a court as soon as practicable, but in any event no later than whichever is the sooner of A, 48 hours after the arrest, or B, the next sitting of the court applicable under subsection 4. 4, where a judge of the court before which a defendant is brought under subsection 3 is of the opinion that defendant A is not likely to surrender to custody, B, has committed or was about to commit another offense, or C, has breached or is likely to breach any condition of the defendant's bail, the judge may revoke the grant of bail and remand the defendant in custody or commit the defendant to custody as the case may require.
Again,
Madam Chair.
yes, Member Jackson.
Where the person fails, where the constable fails to bring the person before the court within the 48 hours, right, or at the next sitting, as set out in 3A and B, what happens? They didn't bring the person before the court. What happens to that person? I'll tell you why I asked the question. I know of cases, and member counsel from Central Kingston, Donovan, will tell us. Many persons are just held. I know of one case of almost 2 weeks. It is not brought before the court, not charged, not brought before the court. But 2 weeks they'll be sitting in jail there.
Member Jackson, my colleague, Member Chuck, will tell you that I'm not a bleeding heart at all. But one thing is for sure is that I am fair. All right. So on this particular provision,
don't personalize it, madam.
no, I say it in that way because of the carriage of the bill. So when we were discussing this clause, we did consider the issue of what consequences should flow. But in light of the broader issue raised, I have flagged and asked Mr. Foreman of the Chambers to provide a little guidance on whether, how do we deal with that matter? Because at a minimum, failure to do things that are to be done really should amount to disciplinary action without prejudice to any other action that may be taken.
I hear you, Madam Chair. I hear you, but tell a man who is sitting in jail for 10, 14 days, not being charged, and he was supposed to have been brought before a judge in 48 hours, that disciplinary action is going to be taken against the
But remember, no, that wouldn't happen because we would have those things being reviewed by the judge. Like I say, there are many problems. And we're seeking to address to them. Sorry?
No, the review thing is every 2 weeks, right?
Remember, this is a person who would have absconded, you know. Right? This is a person who would have absconded.
Okay.
So if that's why I made a comment that I'm not a bleeding heart.
That gives a different flavor.
Not a bleeding heart. Because this is a person who would have demonstrated that he utterly disrespects the law. Because the
person absconded. No, man, you don't have to overstate it. The person.
Oh, you mean you want to state your point, and when I come to state my point, I mustn't overstate it?
I say that if we agree, we don't have to argue.
So, why you didn't apply that when I told you about consequences flowing?
You made the point. No, you made the point that it relates to persons who have absconded bail. They were given bail and abscond. And I'm pulling back in those circumstances. That's why I said that argue the point.
Member Jackson, I have been at pains to say, read fully and carefully. People may be pleasantly surprised.
Well, Madam Chair,
balance that this law has struck.
Madam Chair, I have always said to public officers and committees, the committees are not only for the members who sit in the committees. It's for the public at large that is going to bear the brunt of what
we are agreed on that. So you don't have to state it.
So if we have to say it 2 or 3 times, that can give
You're going to breach your own principle of overstating a point that we are agreed on?
Oh, know that you say that you agree, we can move on.
Before you come in, Member Rodriguez Campbell. Member Williams?
Yes. Just a clarification here. I don't know if I'm understanding clearly here. Does section 15.2, and I'll read it. It says, notwithstanding subsection 1, a defendant who is released on bail may be arrested without warrant by a constable if the constable has reasonable grounds for believing that the defendant is not likely to surrender to custody.
Let me give you a classic example.
No, I'm just asking, yes. This wouldn't refer to the person who actually absconded. This would be the person who is actually on bail, but the officer, and it's also a clarification, and the officer is of the view that this person is not likely to surrender to custody. Yes. Am I interpreting it correctly?
Yes. So, for example, if on the day that is fixed for the court hearing, say, for example, outside of the court, unfortunately, sometimes persons are waiting their matters to be heard, may not all be able to be accommodated in the court building, and you see the man going in another direction, driving away, etc., etc.
Yes.
Or we've had a case, a humorous case in Black River, where on a court date, a defendant was seen jumping on a boat, going away to sea, when he should have been heading to court. So it contemplates those kinds of situations. Yes.
Yes, but
in other words, so it necessitates quick action in the circumstances.
Yeah, but what I'm trying to get at, the 48 hours, let's look at subsection 3. A constable who arrests a defendant pursuant to subsection 2, which is the section I just pointed out, shall cause the defendant to be brought before a court as soon as practicable, but in any event no later than whichever is sooner, or 48 hours.
So 48 hours takes into account a weekend, for example. So if you catch them on a Thursday, court is sitting, take them to the court the same day. If you catch them on a day when the court is not sitting, for example, on a weekend, then it means that you take into account the Saturday and the Sunday and the next sitting. So whichever is earlier.
So this person will be defined as absconding in this context. Because I'm just trying to get some clarification, because earlier on you satiated Member Jackson's concerns regarding the
so
non-compliance to the 48
remember, in our
hours.
jurisdiction is not only whether it has happened, is the likelihood of it happening.
Okay.
So even for constitutional review, right? If something is likely to breach your rights, not that it has actually, you provide for it. It is a likelihood of it happening. Because of the duty to surrender to custody. So you're wondering, let me hear the wonder.
Yeah, so, you know, I'm just wondering if it is likely to happen, if it has yet matured and it is actually absconding, you know.
It's a foreman.
That kind of inchoate.
Assist.
I mean,
yes.
Yes.
Sorry,
You know,
I'm not helping with the rationale. I'm just pointing out that this is one
No, the
feature
point I'm
in the
making.
Sorry,
that
I'm not hearing. It is?
just highlighting that it's in the existing legislation in the, section 16, 3 of the Act had similar provision. So it's not a new concept. That doesn't help explain how it might arise. I'm just adding that to the context of the discussion.
So it's like an attempt. Remember, an offense includes an alleged offense, and in law you have the inchoate offense, an attempt. Yes,
that's
that
what
is
I'm
really
trying to get at.
That's a principle, the principle underneath it. Inchoate.
Madam Chair,
Yes.
Chair, just to, on that same point, it's on a 15 to that member Donovan raised. When I heard the Chief Parliamentary Council reading that provision, what pops into my mind, is that somebody is on bail. A police officer believes he shouldn't have been granted bail because he's not going to turn up to court. And it says the constable has reasonable grounds for believing that the defendant is not likely to surrender to custody. Not likely to surrender to custody. And then he arrest him because he believes, no proof, just believe that he will not show up in court. Remember that court, the court date is set for about 3 months from now, or 4 months. And the day after he was granted bail, the officer believes that he will not show up. He will not show up. He arrests him, and that's okay.
Let me,
Madam Chair, I just wanted to, this is Nadine.
Yes,
I
Ms.
need to
Wilkins.
be on the camera, sorry. I just wanted to point out that it's not necessarily that the person must appear in court. If it's a pre-charge situation, it could be that the police is ready to charge them now and are finding that they are not. For whatever information they may have received, that based on that information, this person is not likely to surrender to custody when we need them to. So it's not just an appearance in court that is being dealt with that truth. Just that.
Okay, all right.
Thank you. All right. Miss Member Rodriguez Campbell.
Thank you, Madam Chair. I'm just seeking your permission to go back to 14, sorry. And it's just to ask a question and probably get some clarification. Is the registrar or deputy registrar of the Court of Appeal a judge? I ask because It says where the deciding official is a judge of the appeal court, the registrar or deputy registrar of the court of appeal, but under the definition of deciding. So I just wanted to
ones who
clarify.
certify the records of the court.
Right, that's what
No,
I thought.
no,
But
yes.
under deciding official, they're not listed as.
No, they are not the deciding official, but they are the person who certify. The purpose of that, you have to relate it back to 14.1b, which says a document purporting to be a copy of any part of the prescribed record.
Okay.
So it's in relation to producing the record. It's really about proof, evidence and proof. So it's a failure to surrender at the date and time prescribed. And because all decisions have to be in writing and served and a record of the decisions produced,
Okay.
then once that record is produced
I think
and
my
it is
reading of it was
certified by the appropriate person who the law says is authorized to so certify it.
Thank you.
Yes. All right, we can go ahead.
Sorry. 16, bail with surety. 1, this section applies where a defendant is granted bail on condition that surety is provided for the purpose of securing the defendant's surrender to custody. 2, the persons listed in Part 1 of the 4th schedule shall be exempt from acting as surety under this Act.
We could just go over to that to indicate murder is not a person.
Right, yes.
So that's a
printing
printing error.
So the persons exempt from acting as a surety are 1, the Governor General, 2, a member of either House of Parliament, 3, a member of the Judiciary, 4, the Attorney General or a person employed in the post of legal officer in the Attorney General's Department, 5, Director of Public Prosecutions, a person employed to the post of legal officer in the Office of the Director of Public Prosecutions, or a person acting as a prosecution in any criminal matter, 6, a permanent secretary, 7, the Chief of Defense Staff, 8, a Justice of the Peace who has considered any issue relating to bail in respect of the defendant concerned, 9, a constable, 10, an attorney at law on record for the defendant concerned in relation to the offense, 11, a person charged jointly with the defendant concerned or charged with aiding or abetting in the commission of the offense, 12, a person who has a criminal charge pending against that person before any court, 13, a person who is not resident in Jamaica, 14, a person who is entitled to immunity from legal process in Jamaica.
Just to say that there's a current exempt list, inclusion, additions to the list is a reflection of the evidence and the data we considered and some of the issues. I don't know if anybody remember the example of the permanent secretary and all of the issues that flowed on that matter, and so many other examples where, you know, after we've looked at it, we decided that we would revise the list that is in the current bail. Member Campbell. No, it's a printing error. It's not. It's just a printing error that came. No, I think it's a printing error. The list starts at the Governor General, number 1. Yes, it's a printing error. But you would suggest the murderer. Cheeky, Member Campbell, cheeky. Yes.
3, in considering the suitability of a proposed surety, regard shall be had to such factors as the deciding official thinks relevant, including the proposed sureties A, profession, occupation, trade or business, B, character and previous convictions, if any, C, proximity, whether of kinship, place of residence or otherwise, to the defendant, and D, capacity to supervise the conduct of the defendant, and to ensure the defendant's appearance in court where required. And the deciding official
you
shall
are
not...
that person. You know what? I'm a parliamentary committee meeting virtually. So the
Jackson, please relieve us of hearing a private conversation. Please mute your mic, Member Jackson. Yes.
And the deciding official shall not refuse a proposed surety unless the proposed surety is exempt under subsection 2 or is, in the deciding official's opinion, otherwise unsuitable for the purpose.
This provision is to ensure that once bail is granted, there is no frustration in the efforts of the defendant to take up the bail. Again, the evidence that we considered and the data, and striking the right balance and ensuring the law is fair. This provision is assisting those issues.
4, the surety shall be required to make a declaration in the form set out in Part 2 of the 4th Schedule and shall have a duty to ensure that the defendant adheres to the conditions of the defendant's bail and appears in court when required. 5, a declaration in the form set out in Part 3 of the 4th Schedule shall be made by a Justice of the Peace, a member of the Jamaica Constabulary Force not below the rank of Sergeant, a Minister of Religion, or a principal of an educational institution other than a pre-primary school, as to the declarant's knowledge of the surety's identity and good character. 6, a recognizance of the surety in accordance with the requirements of subsections 4 and 5, and in the form set out in Part 4 of the 4th Schedule, may be entered into before such person or description of person as the deciding official may in the prescribed record specify, or if no such specification is made, A, where the deciding official is a constable, a justice of the peace, or a judge of the parish court, before any judge of the parish court or clerk of a parish court. B, where the deciding official is a judge of the Supreme Court or Court of Appeal, 1, before any of the persons specified in paragraph A, or 2, where rules of court otherwise provide, before such other person as may be so otherwise provided in the rules. 7, where a surety seeks to enter into a recognizance of the surety before any person in accordance with subsection 6, but that person declines to take the recognizance because the person is not satisfied as to the surety's suitability, the surety may apply to A, the deciding official who fixed the amount of the recognizance, or B, the parish court for the parish in which the surety resides, and then the next word should go back to the margin, for that deciding official or court, as the case may be, to take the recognizance, and the deciding official shall, if satisfied as to the surety's suitability, take the recognizance. 8, where pursuant to subsection 7, a recognizance is entered into otherwise than before the deciding official that fixed the amount of the recognizance shall have full force and effect as if it had been entered into before that deciding official. 9, where a deciding official grants bail to a defendant but is unable to release the defendant because no surety or no suitable surety is available, the deciding official, A, shall fix the amount in which the surety is to be bound, and subsection 6 and 7 shall apply for the purpose of enabling the recognizance of the surety to be entered into subsequently. And B, may reduce the amount fixed under paragraph A for the purpose of enabling the release of the defendant on bail. 10, a person who, in any declaration required under this section, makes a statement which a person knows to be false in any material particular, commits an offense, and shall be liable on summary conviction, therefore, before a parish court, to a fine not exceeding $3 million, or to imprisonment for a term not exceeding 3 years, or to both such fine and imprisonment. 11, notwithstanding the provisions of this section, the deciding official may permit a defendant to provide surety for himself if, A, the defendant provides proof of the requisite assets, and 1, has been offered bail, but is, within such period as the deciding official may consider reasonable, having regard to the nature of the offense concerned, unable to provide a suitable person to act as surety on the defendant's behalf, or 2, is not likely to be sentenced to imprisonment on conviction for the offense, and B, the deciding official is satisfied that the defendant is not likely to abscond if released on bail, commit an offense while on bail, or breach any condition of bail. 17, forfeiture of security or recognizances.
To say that we have ensured that once bail is granted, having been properly assessed, we minimize any administrative efforts that could frustrate the taking up of the grant of bail.
1, where bail is granted to a defendant and a surety has provided security for the purpose of securing the defendant's surrender to custody, and the defendant A, fails to surrender to custody, or B, breaches any other condition of the defendant's bail, the court having jurisdiction in respect of the offense concerned may order the forfeiture of any amount up to the full amount of the security. 2, where a court orders the forfeiture of any security pursuant to subsection 1, the court may declare the portion of the monetary value of that security that is to be forfeited, which may be any amount up to the full value of the security as the court thinks fit, and shall order that the remainder, if any, be paid over to the person entitled thereto. 3, security which has been ordered to be forfeited under subsection 1 shall, to the extent of the amount ordered to be forfeited, A, where it consists of money, be accounted for and paid in the same manner as a fine imposed by the court would be. B, where it does not consist of money, be enforced by such parish court as may be specified in the order. 4, this section shall have effect in addition to any other provisions in law relating to the enforcement of recognizances entered into in criminal proceedings.
Madam CPC, do we need to specifically provide for the carrying over of existing sureties in the same way that grants of bail before would carry over? Or would that provision cover it? Very well. Just wanted to point out that this section deals with the consequences that flow when there is any failure to honor the obligations. Recently, I read the report of the defendant who turned up for trial in respect of the murder of a former member of this House, absconding, and the bond being forfeited in the full sum of just a little under $1 million. Those who followed the news. So, we are ensuring that once bail is considered and granted, administrative efforts do not frustrate the taking up of the bail. We're also standardizing the practice from one parish to the next and across jurisdictions. If only you know the issues that have existed. So persons must pay particular attention to the tidying up that has taken place with these provisions. Yes?
18, release of surety or refund of payment. 1, in any of the following circumstances, a surety shall be released from the obligations under the recognizance entered into by that surety. A, where a court grants such release on an application made in accordance with subsection 2. B, where a null prosequi is entered in relation to the defendant in respect of whom the surety was provided. C, where the matter against the defendant in respect of whom the surety is provided is dismissed and a certificate of dismissal is issued by the court. D, where the defendant concerned is acquitted or convicted, and the court concerned shall issue to the surety a release in the form set out in Part 5 of the 4th schedule.
I just recall one of the submissions asking for greater specificity on the type of nulle prosequi entered. I think when we do the matrix, we'd consider that.
Okay. 2, an application made by a surety for release from the obligations under recognizance shall be in writing to the court having jurisdiction to try the offense in relation to which the defendant is released on bail, and the surety may attend before that court for the hearing of the application. 3, where a surety is released in any of the circumstances specified in subsection 1, any amount paid by the surety pursuant to Section 83B shall be refunded. But if a fine is imposed on conviction of the defendant, that amount may, with the surety's consent, be applied toward the payment of the fine. 19. Prohibition of agreement to indemnify surety. 1. No person shall indemnify or offer or agree to indemnify a surety against the possibility of loss arising from the absconding of the defendant, and a person who contravenes this subsection commits an offense. 2. An offense on subsection 1 may be committed whether a. the offer or agreement is made before or after the person to be indemnified becomes a surety, b. the person to be indemnified becomes a surety or not, or c. the offer or agreement contemplates compensation in money or money's worth. 3. A person who commits an offense under subsection 1 shall be liable on summary conviction, therefore, before a parish court, to a fine not exceeding $1 million or to imprisonment for a term not exceeding 1 year. 20. Property not to be used concurrently as consideration for surety. 1. A surety shall not, without obtaining the prior approval of a court, offer as security for acting as surety for a defendant property that constitutes security for the surety of another defendant. 2. A surety who knowingly contravenes subsection 1 commits an offense and shall be liable on summary conviction, therefore, before a parish court, to a fine not exceeding $1 million or to imprisonment for a term not exceeding 1 year. 3. In deciding whether to give approval for the purposes of subsection 1, the court shall have regard to the sufficiency of the value of the property to cover the securities concerned. 21. Declaration of bail center. 1. The minister may, by order published in the Gazette, declare any facility to be a bail center for the purposes of the attendance of child offenders released on bail. 2. A facility that is immediately prior to the commencement of this act, a bail center under the Bail Act 2000, shall be deemed to be a bail center declared under subsection 1. 22. Power to make regulations, etc. 1. The minister may, subject to affirmative resolution, make regulations generally for giving effect to the provisions and purposes of this act. 2. The minister may, by order subject to affirmative resolution, a. amend any of the schedules, b. amend any monetary penalty imposed by this act. 23. Repeal. The Bail Act 2000 is repealed. 24. Amendments to other enactments. 1. The Constabulary Force Act is amended a. in Section 24 by deleting the words on a charge of murder, treason, or treason felony and substituting, therefore, the following: on a charge for a. murder, treason, or treason felony, or b. any offense under the Firearms Prohibition, Restriction, and Regulation Act involving the unlawful manufacture of, dealing in, acquisition of, possession of, or use of a prohibited weapon as defined in Section 2 of that Act. B. In Section 25 by deleting the words after being so required. C. In Section 50 F3A by deleting the word 24 and substituting, therefore, in each case the word 48. 2. Section 67 of the Judicature Parish Courts Act is amended by inserting next after the words witness or prisoner the words any issue concerning the matter of bail. 3. The Justices of the Peace Jurisdiction Act is amended in Section 32 by inserting next after the words according to law wherever they appear, in each case the words including determining the question of bail in accordance with the Bail Act. And B, in Section 50, by inserting next after the word bail the words in accordance with the Bail Act. 4. Section 34 of the Larceny Act is amended by deleting the words in that behalf shall be guilty of felony and on conviction thereof shall be liable to imprisonment with hard labor for any term not exceeding 7 years, and substituting therefore the following: in that behalf commits a felony and shall be liable on conviction, therefore, A, before a parish court, to imprisonment for a term not exceeding 5 years, or B, before a circuit court, to imprisonment for a term not exceeding 7 years. 5. The Towns and Communities Act is amended in sections 19, 20, 24, and 25, in each case by inserting next after the word bail, the words in accordance with the Bail Act. First schedule sets out the form of notice of appeal by a defendant against the conditions of bail. Second schedule, part 1, sets out offences in respect of which bail may only be granted by a judge, and those offences are murder, any offence under sections 2, 3, or 4 of the Treason Felony Act, any offence under section 3 of the Malicious Injuries to Property Act, that's arson of a dwelling house. 4. Any offence under section 13, predator larceny, or section 42A, extortion of the Larceny Act. Any of the following offences under the Offences Against a Person Act. Section 8, conspiracy or soliciting to commit murder. Section 13, administering poison or wounding with intent to murder. Section 14, destroying or damaging building with intent to murder. Section 15, setting fire to a ship with intent to murder. Section 16, attempting to administer poison, etc., with intent to murder. Section 17, by other means attempting to commit murder. Section 20, shooting or attempting to shoot or wound with intent to do grievous bodily harm or with intent to resist or prevent the lawful apprehension or detainer of any person, or wounding with intent using a firearm. Section 69, child stealing. Section 70, kidnapping. 6. Any of the following offences under the Dangerous Drugs Act. A. Section 3, import and export of raw opium and coca leaves. B. Section 5, cultivation of opium or coca leaves. C. Section 6, import or export of prepared opium. D. Section 7, manufacturing, selling, using, etc. prepared opium. E. Section 7A, import or export of ganja. F. Section 7B, cultivation, selling, or dealing in or transporting ganja. G. Section 8, import or export of cocaine or other applicable drug. H. Section 8A, cultivating, selling, or dealing in or transporting cocaine or other applicable drug. Section 9, manufacture and sale of cocaine or other applicable drug. Section 11, trade, etc. in new drugs. Section 21A, using the postal services for drugs. 7. Any offense under Section 4 of the Trafficking in Persons, Prevention, Suppression, and Punishment Act. 8. Any offense under Section 10 of the Child Care and Protection Act, that's trafficking in children. 9. Any of the following offenses under the Sexual Offences Act. Section 3, rape. Section 4, grievous sexual assault. Section 5, marital rape. Section 7, incest. Section 8, sexual touching. Section 9, sexual grooming of a child. Section 10, sexual intercourse with person under 16. Section 11, householder, etc., inducing or encouraging violation of a child under 16. Section 3, indecent assault. Section 15, abduction of child under 16. Section 18, procuration. Section 19, procuring violation of persons by threats or fraud or administering drugs. Section 20, abduction of child with intent to have sexual intercourse. Section 21, unlawful detention with intent to have sexual intercourse. 10, perverting the course of justice. 11, a terrorism offense as defined by Section 2 of the Terrorism Prevention Act. 12, any offense under Section 3 or 4 of the Child Pornography Prevention Act. 13, any offense under Section 4, 5, 6, 10, or 11 of the Malicious Injuries to Property Act. 14, any offense under the Law Reform Fraudulent Transactions Special Provisions Act. 15, any of the following offenses under the Criminal Justice Suppression of Criminal Organizations Act. A, Section 3, forming or establishing a criminal organization. B, Section 4, recruitment of a child to criminal organization. C, Section 6, being part of, participating in, or facilitating serious offense by a criminal organization. D, Section 13, taking retaliatory action. 16, an offense under Section 21 of the Law Reform Zones of Special Operations, Special Security, and Community Development Measures Act, that's failure to disclose identity, etc., on request. 17, an offense under Section 5(4) of the Unlawful Possession of Property Act. Part 2 deals with offenses for which applications for bail shall not be made after conviction. And those offenses are 1, murder. 2, any of the following offenses under the Firearms Prohibition, Restriction and Regulation Act. Section 5, possession of prohibited weapon. Section 6, stockpiling. Section 7, trafficking in prohibited weapon. Section 8, possession of prohibited weapon with intent to traffic. Section 9, manufacture of prohibited weapon or possession of device therefore. Section 10, dealing in prohibited weapon. Section 12, prohibition or diversion. Section 14, use or possession of firearm or imitation firearm in certain circumstances. Section 15, possession of firearm or ammunition with intent to injure or cause damage. 3, any of the following offenses under the Criminal Justice Suppression of Criminal Organizations Act. Section 3, forming or establishing a criminal organization. Section 4, recruitment of a child to criminal organization. Section 6, being part of, participating in, or facilitating serious offense by a criminal organization. Section 13, taking retaliatory action. 4, an offense under Section 21 of the Law Reform Zones of Special Operations, Special Security, and Community Development Measures Act, as failure to disclose identity, etc., on request. 5, any of the following offenses under the Law Reform Fraudulent Transactions, Special Provisions Act. Section 10, knowingly obtaining, possessing, transmitting, distributing, etc., identity information. Section 11, obtaining a benefit by menace. Those are the offenses. Third schedule sets out notice of appeal by the prosecution. Fourth schedule was read. Part 1. Part 2 is the statutory declaration to be made by a surety. Part 3 is the declaration as to the surety's identity and good character. Part 4, recognizance of surety. And Part 5, the form of release of surety. Memorandum of Objects and Reasons. A decision has been taken to enact legislation to repeal and replace the Bail Act, having regard to the fact that the existing act was enacted prior to amendments to the fundamental rights and freedom provisions contained in Chapter 3 of the Constitution of Jamaica, the need for new provisions to address circumstances peculiar to Jamaica, and the need for greater clarity in certain provisions of the existing act. This bill seeks to give effect to that decision and to effect consequential amendments to other enactments.
Just to say, Madam CPC, we may have to just put a little more in the memorandum of the policy, the peculiarities in the Jamaican context regarding the investigation of offences, just to give a greater picture of the pre-charge regime in particular, which is already set out in the cabinet documents. All right, so
you want to further amend the memorandum of objects and reasons.
Just to add something to it, remember the memorandum of reasons and the memorandum of objects and reason is a glimpse into the policy behind the law. Based on some of the comments that came, they were just asking for certain things to be specified.
No, ma'am, I'm very, very, very clear on that.
Oh, okay, got you. All
but
right.
I'm only thinking. No, I was smiling to myself when you mentioned about amending the
Yes.
In that you probably want to say too, you want to be able to fight crime.
No, we don't need to put that in the law because the case law tells us that to the extent that mail may be properly withheld from a defendant where there is reason to suspect that the person, if released on bail, would commit an offense, it has a crime prevention and a crime fighting component. And that is already recognized in the common law.
I just thought that you want to be a bit more explicit.
This is not a primary crime fighting measure, Member Jackson. All right, it is addressing real issues in the criminal justice system, real issues that are not only on the crime fighting end, but also matters within the courts and at different stages of criminal proceedings. All right, so members, we are at the end of the read through of the bill. What will follow after this? Well, first of all, let me ask, any questions, any comment? You can
I have a question, Madam Chair.
Yes, members.
Just a quick question to the to CPC. In respect to the declarations that are being done, how does need that the person presenting a needs identification? Because the requirement for the bailiff, the JP, is to establish the identity of the surety and so forth. How does that play now with needs being available? Needs ID.
Oh, we actually thought of that, you know. It's interesting that you raised it. Remember now we're in the pilot phase of NIDS, and I think all of that will become easier for persons who opt into the NIDS system. Remember, NIDS is not mandatory, right? But it will enable, the administrative ease that opting into NIDS will enable will become evident to those who opt in very short order. So we did consider how other reforms taking place will make life a lot less challenging for persons. Member Sinclair, I'm happy you raised it. It will only inure to their benefit.
Yes, it should. Yes. And I would suspect it should be great encouragement for persons to participate in it. Getting themselves onto that. Getting a needs identification.
Yes, but again, you will see how we have standardized, because some of the concerns we monitored included efforts persons felt were frustrating them in the take-up of bail. And, as part of striking the right balance and ensuring that once a decision is made, that it is proper to grant bail in the circumstances, because there isn't sufficient cause for keeping the defendant in custody, then we want to ensure that everything else that flows from that is made as easy as possible.
Thank you, Madam Chair.
All right. And as I had said, I didn't anticipate much controversy around the other issues. And evident from the discussion that flowed from the reading of those provisions. So we are now on to other business. Today's meeting brings to an end the schedule of meeting dates previously provided to all members of the committee. The Parliament took its recess yesterday, and Cabinet is in recess. And of course, I would ask whether members are amenable to a meeting next week, but it's Christmas week, and I know members of the lower house want to attend to constituency matters and family matters. So it is the norm that we take a break over the season. It's not just to refresh, but there are important administrative work that needs to be done the minutes of yesterday's meeting and today's meeting, the matrix setting out the comments, suggestions by those who presented, and we need time to respond. The technical teams need time to respond. Members need time to consider. So there are important administrative steps to be taken that will lengthen the time of consideration and deliberation by the committee. Having regard to the calendar, we're proposing the next meeting date to be Wednesday, January 11 at 10 a.m. with a caveat that the PAAC may need to meet at 10, and if it does, then our meeting would be pushed down to 2 p.m. And then after that, we will reserve January 18 and 19 at 10 a.m. 18 and 19, Wednesday and Thursday. '26 if need be. Need may not be, but if need be. Yes, 26th if need be. We're hoping that we can have the report ready for tabling in the House on February 1, no later than. And then we would debate the following week, 8th and or 9th in the House, with a view to passing the bill then. Now, I have to say that because all of us have been here, other matters also will be extended. We have the Enhanced Security Measures Law to come after this. We have the bill to amend the Constitution and the work of the Constitutional Reform Committee to come. It's the same technical team, same CPC, same minister working. And sometimes when members of the public question the pace at which things are done, they do not always consider that the work is being done by the same set of persons. The committee clerk, in her apology for not having the minutes of yesterday's meeting present, expressed the reality of the constraints they face. The staff has dwindled when she is in the meeting every day. I mean, they have produced meeting minutes from one day to the next, but you hardly get time to do anything else, and people still have to attend to personal matters. Yes. Yes. All right, so we will work out behind the scene, but just mark the dates. Mark the dates, because only one set of meetings can take place in the chamber at any given time. And the constraints are real. The constraints are real. Yes. Understood. Understood. Sorry? The 26th is at 2 for if need be. Right. So that probably, yes. So what is to come after this is that between now and January 11, the matrix and the 2 minutes will be made available. We'll ask every member to go through. We may do a caucus of the government side. We may have to have the technical team look on, and I have no doubt that opposition members will do their own caucusing too. And we come back to deliberate on the knotty issues. I will just ask that as soon as the documents are provided, please take the time to read them. This has been a very vibrant committee because I think the issues are so, critical. And just to say, as I close out, that yesterday I pointed out the reality of the context in which this bill is being deliberated on. there is a competition for views to prevail and an approach to address the problems that we all agree exist. The strength of any forum is a diversity, but for every strength there is a flip side. And just to say, in case anyone harbors any doubt, this chair welcomes diverging views. Don't be put off by the passion with which I may present my points in response. Probably it's the downside of lawyering, and especially when we come to discussions on the law. But I think every member, or for the most part, the members in regular attendance have made good contribution. And it doesn't matter what our views are. I value the contributions made. I want to thank the hard-working technical teams, my own Office of the Parliamentary Counsel, and in particular the Chief Parliamentary Counsel, the Law Reform Department, and the Attorney General's Chambers, and you committee members. This is just a learning experience for all of us. And some of you have taken the time to share how much you really have learned. Not everyone on the committee is a lawyer, and so some issues, the views are really diverse, and that should be heralded as a strength. I want to thank the support staff, including the committee clerk and all of the clerks who have worked, and to use the opportunity to wish everyone a holy and blessed and enjoyable Christmas season. I celebrate the Christ in the season, regardless of your views, when I say you generally. But get a little rest. Some of us will have no rest because of the work schedule that we have, especially on the constitutional reform front and the other legislative matters that we have pending. But I really want to wish you all a good Christmas, and may we emerge, God's willing, with renewed strength and clarity, and, refreshed for the work ahead of us. I think the people of Jamaica are blessed to have parliamentarians in both houses who genuinely care and are committed to doing better on their behalf. And I think sometimes it is the expression of the care and commitment that others may read differently. But I think there is impatience in all of us to get solutions, quicker solutions that are of higher quality, and to ensure that our peoples are better served. So on that note, I will invite anyone who wishes to make a comment. If there is none, then the date of the next meeting is fixed at January 11, 2023, Madam Clerk, Committee Clerk, at 2 p.m. And thereafter, January 10 p.m. or 10 a.m. or 2 p.m., depending on whether the chambers is required for a meeting of the PAC. Thereafter, January 18, 19, 26, we look to table on February 1, debate and pass between February 8 and 9, subject to the sittings of the House. Madam CPC, I don't know how we're going to manage with the other ambitions that we have for the constitutional reform agenda and all of the other work and all of the other pieces of legislation you're working on, and our efforts to coordinate the work with the other ministries that have portfolio responsibility for the matters that I highlighted that are pending at various stages. That will be announced soonest, but I am foreseeing that we will have to meet. That certainly will be my request, Tuesdays and Wednesdays, to get the legislative work done in the time frame that we have set. The constitutional reform work is far advanced behind the scene. All right, on that note, colleagues, best wishes for the season, and may you have a lovely rest of the day and weekend. Thank you all. Yes. Meeting, will someone move for the adjournment of the meeting? Members Williams and Campbell Rodriguez at 1:26.